Oh, so sorry about that. My network had issues and it logged me out. So sorry. Please come our mentor. Okay, Mr. Folarin, you're already giving your discourse, sir.
What's that? No, I'm not giving my discourse. We haven't started yet.
Oh, okay. My network. So, please, we would like to have you, sir. IP protection, FinTech, sir. Where we will be issues from our mentor. Due to issues we had. So we would just like to have from you on the topic. Then we'll take.
Okay. So I will not be using slide, if you don't mind. That's okay with you guys. But I would like to approach. I'd like to adopt a style that will be, if you permit me, also I would also like to stay off cam. But I would like to also adopt a somewhat conversational style as well to the topic in question. So we're talking about intellectual property protection in the fintech space or in the fintech industry. And I think the topic is a very, am I audible? Can you hear me?
Yes, sir, we can.
Yes, sir, we can hear you.
Great, great. It's a very topical issue. It's one that is central to the entire fintech conversation. Of course, there shouldn't be any need to define what fintech is, but by its very definition, just by definition alone, the what you may call the scope of the fintech space clearly it rests quite squarely on, or it has at its foundation innovation. It is the application of technology to financial or to provide new types of financial services or existing financial products to a new set of customers in a new way, to deliver existing set of financial products or existing financial products to a new set of customers in a new way, or to create new sets of financial products altogether. So that's the novelty and the innovation in the fintech space is very, very central to the emergence of the fintech sector, if I may refer to it as that. And so whenever we're talking about innovation and creativity, of course, naturally one must have a conversation about protecting that innovation and protecting the creative elements that underpin that innovation. And that's where intellectual property protection comes to play. And so there are several ways that innovation is expressed in the fintech space. So we've talked about service level innovation, for example, and that service level innovation, I'm referring to innovation in the type of products that are available. So, for example, we have now there are companies that provide credit swaps. You can swap credit as phone call credit can be swapped for cash or for money. That's a new service that did not exist 10 years ago, and 20 years ago, there was no one could have done a projection, at least no one on this side of the Atlantic Ocean could have projected that such a service would even be available. But then you have companies quite a number of companies that provide, provide customers the ability to change credit to cash or to convert credit to cash. So you have that service level innovation. So new services are being created by innovation in technology. And then you also have customer-based innovation. So the ability, and by that I refer to the ability to provide regular services or regular financial services to customers either quicker or in a more reliable and more secure way or in a more convenient way, and you find this in maybe the OPAs, for example, that you can tell once a transaction is made, once a transfer is done, you can tell almost immediately, even when network is very bad, that a transfer has been effected from this account to that account. And that's why you see that the market always tends to follow this type of innovation, because all you have to do is to look at who is using it, who is enjoying the benefits of this innovation. With boat riders, for example, almost a very large number of boat riders, in fact, perhaps maybe almost 95% of the boat drivers that I have spoken to, use a particular fintech app. And it's not a coincidence. There's a reason why they gravitate towards that app is customer level innovation. And then of course there's innovation in terms of security, so the security of the transaction, and so on and so forth, different levels of innovation depending on the different types of financial services being offered. And this innovation, in order for innovation to be sustainable, innovation has to be protected, and the innovator oftentimes the law requires that there is a need to reward innovation in order to encourage more people to innovate or to encourage more innovators to do what they do. And so that need to reward innovation is one of the key functions of intellectual property rights, intellectual property law. And that is what IP, that's the entire conversation around IP in the fintech space, or protecting innovation in fintech space. The question really is, how do we ensure that we can protect the innovation created by these startup companies, these tech companies, whether it's at whatever level, whether it's innovation in terms of security. And for example, a good example of that would be perhaps maybe a money point. So if it's that level of innovation, or whatever level of innovation. So IP rights or IP law exists to protect and to ensure that to protect this innovation and to also allow the innovators, give them the opportunity to exploit it sufficiently. Are we together?
Yes, sir.
Great. So that really is the function of intellectual property protection in the fintech space. For the purposes of this conversation, we will limit our definition or the scope of intellectual property to patents, trademarks, copyright, and perhaps industrial design, perhaps. And this is because there are several other intellectual property rights, or several other ways by which intellectual innovation can be protected. But for the purpose of this conversation, we limit scope to trademarks, patents, industrial designs, copyright. Trademarks, patents, copyright, and industrial designs. And I think the most important, or one of the most important rights would be copyright, in the sense that many fintech services are offered via some sort of mobile technology. And the means by which these services are offered is through apps, mobile apps. Of course, there are some other there are other means by which technology can be accessed. I mentioned Money Point. Money Point uses a point of sale um, device, and they have other devices as well. So there are a number of other ways by which these services can be accessed, but by far the most common way is through mobile application, a mobile application interface, and that's mobile apps. And by default, mobile apps are protected by copyright law. And this is because mobile apps are actually at their roots lines of code that are written or that are treated by law as literary works. In fact, as we're speaking now, an OPay notification just popped up on my screen. But essentially, what you have is lines of code, and then those lines of code are now represented by a user interface, which we interact with as the users, the graphical user interface, or the user interface and user experience modules. So copyright law at its core protects the code that is used to write the applications or the software. And this goes a long way, of course, to ensuring or to giving the developers or the fintech companies an upper hand, if you may, for protecting their own whatever innovative steps they are taking in building their apps. What I tend to find that is very common these days in Nigeria is that many fintech platforms use open source technology. So a lot of them actually start out with open source technology. And so you have a situation where looking at just the source code alone, you find that at its core or at its roots, there's little differentiation in terms of if you're looking at code, if you're looking at the line level coding, there's little differentiation from one app to the other. And yes, we will tend to find some apps that are written entirely from scratch that have their own unique features. And I'm not talking about the look, that's the graphic user interface. I'm talking about line level, that's code level interface. So you have copyright protecting the code, the source code. And we don't really have many Nigerian cases, we don't have reported Nigerian cases, but there are quite a number of foreign cases that discuss the importance of the ways in which copyright law protects software code. I think Microsoft has filed quite a number of Microsoft cases from the US and other common law cases as well. So copyright protects the code. Copyright also protects the user interface and the pictorial element of the app's design. And I think that's also a very major component of these fintech platforms, if you may. It's a major component. The copyright protects them. And the reason why this is important is because user UI UX, that's user interface, user experience, is a very, very key part of the technology space these days. I have a particular client who rebranded some time ago, and I recall we spent several hours. In fact, we had a series of meetings going over the user interface. Should this button be here? Should this button be there? What should the color of this button be? Should it be round? Should it be oval? Should it be a square? What should the onboarding process be like? How many steps should customers have to take, to before they are onboarded from scratch, from download to onboarding. Let's minimize the number of steps, and so on and so forth. And then of course balancing that with KYC, that's know your customer legal requirements of the know your customer scheme. Also very important. So you find that the visual elements are also very, very key as well. That's how when you look at your app, okay, this is PalmPay, or this is OPay, or this is whatever pay, Jumia Pay, etc. So these at that level, the visual elements are protected by copyright law. Then we'll very quickly go to trademarks. Trademarks protect the brand names and the various marketing and branding slogans. Now, trademarks are perhaps one of the most important um, assets that a company can have as far as its reputation goes. In fact, it's the most important asset because all the money or every investment that is made in promoting a brand is actually an investment in a trademark, whether it is registered or unregistered. And of course, of all the intellectual property rights, trademarks are the only rights that are renewable perpetually. So every other intellectual property right is finite, has a starting point, has an end point. But trademarks are renewable infinitely, and so trademarks are very important. I find that in Nigeria, we there is, I think now there's some differentiation. In the past, you would find a situation where you'd have a Kuda, you have a Kudi, you find companies with very similar names. And I'll ask myself, what's going on here? But I think one of the reasons why this was so was because the many of the developers and many of the service providers were more interested in providing a service first before all the other aspects of branding and even IP protection or legal protection of the brand. But I think these branding issues are being resolved carefully, is that the right word? Yeah. Branding issues are being resolved in the market one way or the other. And so that is because the brand, if you go on Twitter, for example, it's very important. A brand's reputation is very, very, very important. When people start calling out, because again, one of the challenges that we have in this part is that our legal system, unfortunately, is not quick enough to address some of the challenges that are faced by users of financial services, whether it's the traditional financial services, the banks, or it is some of these fintech companies. So our legal system is oftentimes not quick enough to respond to the challenges. A wrong transfer is made to someone's account. You need you need to get an order of court, ASAP, and then it takes you like what, maybe 2 months before your case is assigned to a court. That's a problem. So because the legal system is not fast enough, people then start to use social media callouts and other means that are more of self-help to get the results that they need. So the company's reputation is very, very important. Then you have patents and industrial designs. Patents are very key. The issue of software patents, that's a topic we might not get into too much today, but one of the earlier cases, or one of the cases that seemed to imply or seemed to suggest that software patents were registrable in the US actually had to do with financial services. So we bills, and in that case, the court had held that you could actually that for certain types of financial services where sufficient innovation was displayed, the Patents and Trademark Office, the US Patent and Trademark Office, could actually grant a patent, a software patent, or a patent for a computer-generated invention. In Nigeria, at the time, it was believed that that wasn't so. Of course, the patent registry has come a long way since then. Now the patent registry grants business method patents and utility model patents as well. And these patents are granted to with regards to software. Industrial designs would only apply to the extent that a device is involved in the process, and I'll reference money point again. The money point of sale device. Once you see a money point POS device, oh, this is a money point POS device. It has its own look. I would be interested to see how innovation can, how they can actually use the uniqueness of their design to drive their brand or to drive their product. Hello? Okay. To drive their product forward. It would be interesting to see how that works. But in a nutshell, I think these are the key intellectual property rights that fintech companies can actually use, or that, assuming that we have people on the call who are looking to serve as either legal advisors, or company secretaries, or compliance officers to fintech companies. These are the key intellectual property rights that one should look out for, when performing an audit or when looking out for, what elements to protect and what elements to register and so on and so forth. It's important to note that copyright is formality free in Nigeria, which means no registration is required for copyright to be valid. Patents, of course, require registration and are valid for 20 years, term of 20 years. Industrial designs are valid for a term of 5 years, renewable for a maximum of 2 subsequent term of 5 years each. And then you have trademarks. Trademarks can be renewed indefinitely. Well, I should also mention that an unregistered trademark is also protected by law, but the extent of protection is not the same as a registered trademark. So, for example, only the holder of a registered trademark can sue for trademark infringement. The owner of an unregistered trademark can sue for damages from passing off or damages for passing off. Passing off is a common law or a court created or a court-based right that the owner of both a registered and an unregistered trademark can apply for. I think, so these are the main intellectual property rights, and for the purpose of this introductory conversation, they are the key areas that one should look out for protection for any, for if one is doing an IP audit or an appraisal, or some sort of protection for fintech innovation. Thank you very much. I hope we can start the conversation now. I'd be very happy to hear thoughts and presentations.
All right, sir. Thank you. Thank you so much, sir, for that introduction into the topic for today. For the presentation, I had earlier said that because of some issues we had, the mentees presentations today.
Okay.
We're having a question and answer section with the mentees to have them more engaged. So please, we would like to take questions from our mentees on the topics. Can have.
Okay, good afternoon, sir.
Good afternoon.
Okay, sir, I don't really get how intellectual property can protect fintech. I don't really get the relationship between intellectual property and fintech. Please, can you explain further? Thank you, sir.
I might need you to explain a little further also. Your question is, you say you don't get the relationship between intellectual property and
Fintech.
And fintech.
Yes, sir.
Okay. Intellectual property. Okay. So in my introduction, but you know what fintech is?
Yes,
Hello?
sir.
Yes. Who am I speaking with? Who's, I didn't quite get your name. This is Dennis. No, this isn't Dennis.
Okay, Hope,
Yeah.
please, we
Was that Hope?
Okay. Yes, sir. It's Hope.
Okay, okay. So Hope, I said just to confirm, of course, you know, we've been talking about fintech, or we've been handling what fintech is. So the relationship between intellectual property and fintech centers around innovation. That's what the connection is. The connection is innovation. Intellectual property rights, as I said in my earlier, uh, they exist to protect innovation, to protect and promote, if you may. So let's look for an example. There's a general now. Before the industrial age, you know, what's before the industrial age, people engaged in subsistence farming. And one of the features of subsistence farming is that you farm to eat. You eat what you produce, essentially. Now, there's a there's a general theory of, and there are several theories that justify intellectual property protection. But one of those theories is that, the same way that a farmer owns everything that he or she produces with their hands or with his or her hands, this idea that you are entitled to the work of your hands, the same way a farmer is entitled to the produce or the product of his or her labor, is the same way that a creator is also entitled to the product of his or her labor as well. So a person who creates something, who creates an invention or who creates something, should be the rationale or this argument, natural law theory, proposes that a creator should be entitled to whatever they own, whatever they create. And so, but then on the flip side of that coin, you have a situation where somebody owns something exclusively, but then at the same time, that person did not, the thing that that person created, was not created in a vacuum. The person relied on um, certain basic components provided by nature, provided by society, by the community. An author uses words from the language that he or she grows up in. An author uses words from the language or from a language that he or she from society. An inventor, if it's scientific, might probably lean on the work of other inventors and discoverers and so on and so forth. So so therefore society has an interest and the public has a right to enjoy the innovation created by the individual. So there's this balancing act that the law tries to achieve between giving exclusive use to the creator and also allowing society to enjoy the rights on the flip side. So to your question, what is the connection between intellectual property and the fintech space? I tried to explain that the entire fintech industry, if you may call it that, is really built on innovation. The reason why we are having a conversation about fintech today is because technology was introduced, or technology became the critical component in delivering financial services to people, to the public. And for the longest time, since the invention of banking, financial services have always been driven by financial service operators or financial sector operators. But for the first time, you now have a situation where technology companies or technology service providers have then started using technology to provide access to financial services to the public. And it is innovative in every concept or in every sense, But then the innovation plays out in a number of ways. I try to also explain that you have, for example, what I would call customer level innovation, which may be providing an existing service. So you could always transfer money with your GT Bank app, for example, or you could always do bank transfers. But there was always this problem of, there's network, or maybe you do a transfer and you don't get an alert, but you are debited, and issues surrounding transfers. We all know those issues, or there were USSD issues. So it's the same service, but then a fintech company that has maybe an algorithm that ensures that maybe uses blockchain, for example, ensures that once a transaction is effected, even before value is transmitted, there's a notification that happens on both sides, to both accounts. That is the same service, is money transfer. But with technology, one company has managed or is managing to provide a better experience to its customers. That is innovation. Now, the person who wrote that code should be allowed to enjoy something, to enjoy the benefit of using that code, maybe even licensing it to others, to exclusively control the use of that code. And that protection is where intellectual property comes in. In some cases, the innovation is a service level innovation. So a new product is being introduced into the market. Depending on the nature of that product, whoever is responsible for either the branding or whatever of that product should have the ability to control the use, or should have some exclusivity over the use of that product or that innovation. And that is where intellectual property comes in. So the objective of intellectual property protection is to protect and promote innovation. And so in the financial services industry, what that means is that it allows fintech operators to provide their own unique service model or unique service product or service offering to the customer. I hope that makes sense. So they can monetize it. So I, for example, as a developer, let's say I write an algorithm that allows you to transfer large amounts of data, with large amounts of information with minimal data. So you might use, so let's say let's say data that might have required 50 megabytes, for example. I write an algorithm that can transmit that information with 10 kilobytes, of data. What then happens is the law says, or intellectual property rights, my rights will allow me to exploit that algorithm. So I can license it to 10 different companies. I can license it to OPay. And if OPay wants, they can decide, you know what, we're going to pay this guy. We would like to buy it from him, or we'd like to get an exclusive license from him. That's how intellectual property works, to help protect innovation in the fintech space. I hope at least this answers your question to some degree.
Cool. Yes, sir. Thank you so much, sir.
Okay, you're welcome.
Thank you so much, sir, for asking. I would like to have other questions. Precious can ask questions. Ikachi can ask questions. We really, really appreciate. So are there other questions from our mentees? I'm sure Mr. Folarin would like to is also willing to help us answer those questions. So do we have other questions?
Yeah, I'm open to conversations. I'm quite sure that in the course of the session, we must have come across some interesting trends across the world. Or in Nigeria, it would be good to, for example, this one of the things and I think I discussed it the last time I was on, has to do with the fact that many fintech companies actually do not engage with the services of IP lawyers, which I think is an unfortunate development. Because one of the things that then happens is that they're not aware of some of these issues. And they might not be aware that, oh, you should first register your name or first confirm that you can use this brand before you start using it, before you go ahead. And even after registering a company, you might still not be able to use, or you might still, the fact that you registered a company name does not automatically mean that you have that brand name is available. You have to do a search at the trademark registry, for example. So I think some of these issues are many fintech companies in Nigeria are blind to some of these issues because they don't engage IP lawyers. So I don't know if this has come up or if anyone has a question around this area.
All right, sir. So I think I would like to ask a question around this topic. So my own question is, okay, when registering for a fintech company, is it going to, which aspect of intellectual property are you registering for? Is it just going to be strictly patent or trademark or copyright? Because I know algorithms can be registered under copyright. So what particular area of intellectual property, if for instance I develop my own fintech, let me say a pay app, and I developed the algorithm for it, and the interface also for it. When registering the fintech as a whole, what am I registering it under? Since it's contained in the fintech, in the app, or whatever app I create is the algorithms, the anything that are unique to my own inventions.
I'm sorry, could you please, I'm not sure I have the question very clearly.
Okay, my question is, if I were to register for my intellectual property for fintech, what under which of the intellectual property am I registering for it under? Is it under copyright, patents, or trademark? Since in the process of developing there is the algorithms that probably are unique to me, which I most likely that are unique to me, which I copyright covers, and the whole interface and everything. But since since the interface in itself, we can classify it under patents. Which exact intellectual property am I registering it under? Am I registering it under as patents? That is, if I choose to register, am I registering it under as patents, as copyrights, or as trademark?
Okay, so that's an interesting question. I think that the first thing that we need to determine will be what is the type of innovation that we're trying to protect. Because as you know, intellectual property isn't just one thing. And in the same vein also, innovation is not just one thing. So the fintech itself, when we're talking fintech, it's not just one thing. So I'll give an example. I mentioned that I have a client who, that one particular client, who were trying to look for a good UI UX fit. They were rebranding the user experience. Now, for that particular client, their unique product offering, they do all the other things. They do transfers, they do savings, but their unique offering is in what do you call it now? Is in insurance. So the provision of insurance, they have this very special insurance package. Now, registering that company. So if we're talking about what are the things I want you to do to get that fintech company up to snuff, I would say the first thing would be, okay, to register the company, ensure that the company exists, because it has to exist anyway. So we say registering the company, number one. And what does that entail? So that entails going to CAC, filling out the memorandum and articles of association properly, correctly, and then doing the registration. The registration will entail a either limited liability or whatever form. You will need shareholders, you will need directors, and so on and so forth. So that's on the one hand. Then on the other hand, we have a company that has been registered. But the question then is, what name will we call this product? Because the company is one thing, and the fintech app is another thing. The product is another thing. So we have to call the app something. Let's call it Payless, for example. So that Payless, we registered the company already. Now, Payless is a brand. So you have to protect the brand by registering trademark. So you register the trademark, Payless. But all we've done is we've set up the company, register the trademark. The app, someone has to design the app or develop the app. Now, the algorithm in the app, it may be that we called a developer, or we engage the services of a developer to help with putting the algorithm together. It may also be that on our own, we decided that we would develop the app ourselves. In any event, or whichever option that is chosen, if we're developing the app ourselves, what it means is that we have the opportunity to then do something with our algorithm. And let's say, just as you said, we have this algorithm that can help us do something. Let's say, if you're using a GT bank, I don't want to use any particular bank, but let's say you're doing a transaction with certain banks, Bank A. For many banks, if network is very bad and your reception is low, the app may not function very optimally. So it may slow down, just as if you measure internet speed as per kilobytes or megabytes per second. So let's say there's a certain amount of data that can be transmitted per kilobyte, and of course at the moment, every time an application is all banks require maybe 10 megabytes per second. So what it means is that if maybe your network is down and you don't have up to 10 megabytes, it will slow down the entire transaction. So let's say Dennis writes an algorithm or writes a program that allows him to do his transfers with 10 kilobytes per second, which is more than 1,000 times, like 1,000 times better than what the current average is. What it essentially means is that your app will be faster. In a nutshell, the app will be faster. People will come to your app. Now, how do you protect that algorithm? The default way is copyright law. But I was saying that the Patents and Designs Registry now has a system by which you can register software patents. That's a whole different conversation. And I'm not sure it's one that we can get into entirely for today. But all these different components are protected by different intellectual property rights. And so, as a result of that, it's not just one thing. So when registering or when setting up a fintech company, one has to think about, okay, there are visual elements to this our brand. You know, is this a copyright issue or is this trademark? You know, is this a brand name or is this a brand element that we want to own or that somebody may use or hijack, you know, that we want to control? Is this code, was this code taken from open source, does it have an open source origin? Or did we write this code? Is this a unique selling point, a unique service offering that we should protect? So that will now determine how or what form of protection is used for that. It may even be, you can decide to make it a trade secret, you know, but that's what will determine the form of protection that adopted. So there's a whole series of conversations that should happen, like an audit if you may, an audit that should be done when a fintech company, you know, sets out to provide services. I hope that helps.
Yes, I sure does, sir. I don't know about our mentees, but you know, this is a very, very interesting topic, and I, for one, still have multiple questions to ask in this space, and I'll still be engaging Mr. Folarin. I don't know about you. Please, I want you guys to also engage and jump in on this opportunity so that we can have Mr. Folarin's. We can learn from Mr. Folarin. He's an expert in this area. So, okay. Hope, you said you have a question. Please, you can go ahead and ask.
Okay. So my question is, how do people, can you guys hear me?
Yes, we can hear you.
Loud and clear.
Okay. How do fintech companies balance protecting their intellectual property while sharing data in the open banking ecosystem? There was a time that a mentor came and he talks about open banking, embedded finance, and so many concepts on that fintech. And open banking is like when a third party gets involved in like the fintech transaction. So now, how do a company protect their intellectual property while also like giving a third party access to their transaction details and stuff like that?
I'm not sure. You asked a question about, I'm sorry, the network was coming and going. Maybe someone should do an algorithm to help us do Zoom calls without these types of hiccups. You asked a question about protecting IP in open banking situations. I'm not sure I got the question correctly. Can you ask the question again, or could you reframe it somewhat?
Okay, so the question is, how do fintech companies balance protecting their intellectual property while sharing data in the open banking ecosystem?
How do they protect their intellectual property while sharing data in the open banking ecosystem?
Yes, sir.
I'm not sure. So it depends on the type of innovation one is talking about. And so there are some types of intellectual property that you have to disclose, because we should also realize that, if you recall, one of the things I said, intellectual property protection really is a balancing act. And it's a balancing act between the state says, okay, owners have a right, exclusive right to own their work or to control the use of their work. But at the same time, this innovation did not come from the moon. You know, it came from a place, whatever effort has been expended, built on something that was done by someone else. You are using this your sweet poem. You did not create the words that you used to write your poem. The code that you are writing, somebody built the language that you are using to code. So there's a balancing act. Now, there's a trade-off that is usually done, and that trade-off usually is you disclose the nature of your innovation in exchange for protection by the law. Now, forms of intellectual property, some forms in the product itself, you have to show. I don't know how to demonstrate this, but for example, your brand name, everybody knows Coca-Cola, for example. That's a brand name. You must disclose the brand name. Do you understand? so the name of the brand is disclosed. With Apple or with mobile phones, for example, also the circuit board. So that's why when you buy an iPhone, it comes with all the innovation in the iPhone, both the hardware and software. But the flip side now is that there are some things that Apple will not give to you when you buy an iPhone. They will not give you the schematics of the iPhone, for example. They won't give you the building, what's it called now? I was going to say the building schematics, but they will not provide you with the IC list, that's the integrated circuit list, or the list of chips and programming codes that were used to program each chip. Do you understand? They will give us the software. You have all the different software on the iPhone, but they won't give you the source code to the software. And that's because what we're buying when you buy the iPhone is just a license to use. It's not a license to own. So that really is how companies protect their innovation. When you give your customers the product, what you're giving your customers is you don't give your customers the source code. You don't give them access to the source code. You give them the app. Although there are software. There are ways by which one can reverse engineer products. But this is, if you look at terms and conditions, many times you find that in terms and conditions, people will say, providers will say, if you try to reverse engineer this software, you're going against the terms and conditions, you violate the terms and conditions, blah, 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 blah. Apple will tell you if you open the iPhone, you void any warranty, whatever. DSTB multi-choice tell you if you break any of these seals or open the decoder to touch anything, you voided the terms and conditions of the warranty and so on and so forth. So that's how companies protect their innovation, to stop people from reverse engineering whatever innovation that we have. So it's not really so much an issue of law, but more of an issue of a business and practicality solution. So I hope I got that question, because open banking does not require that. First of all, well, open banking. Let's go with that term. Open banking doesn't require that you should disclose your source code information to your users, for example. However, if you decide to seek a patent, for your seek patent protection, to register a patent for your source code, you have to disclose the what do you call it now? The source code, or you have to disclose how that source code works in order to get the patent application, to have the patent granted. So that disclosure is given in exchange for the exclusivity afforded to that application. But I'm not sure that really fits into. I think open banking really centers around access to financial data. So the openness there has to do with financial, or with the data, with consumer data. So providing customers' data or access to customer data to third parties. That's a whole different conversation. But in terms of, we're talking about how protecting FinTech elements, protecting innovation in an open environment. If I can hazard, that's what you mean by open banking. I would say that the first way is to use warranties and some of these techniques. And of course, you're not providing your source code to customers. You're not providing them with the finished product, that's the app itself. Does that answer? I hope that answers your question. Hope. No pun intended.
Thank you so much, sir.
Okay.
Still taking questions. Please, you can jump in and ask your question, and we'll like to have you ask your questions. But while we wait for others to ask questions, I think my second question would be, though in the direction Hope has asked, in a situation where I register my FinTech, I've developed my app and everything. I've registered my intellectual property, the trade name, the copyrights and everything for the algorithms and everything. I've done all that. How do I cover up for a situation where, since intellectual property laws are territorial in that sense, how do I cover up for things like where maybe, for instance, sometimes when we go to download apps and you type in the name of a particular apps, you see many other apps with very similar names, similar interfaces that may resemble a particular app, my particular app. How do I, as a FinTech innovator, right, go to protect my my FinTech, my app in that sense, seeing that the laws that governs intellectual properties are territorial. For instance, like in spaces where maybe say this app now, or the app that I notice has a similar design or interface with mine, is one, maybe the developer is, let's say, in America or in another part of the world where the legislations that can help me deal with the issues around that doesn't cover up to those areas. How do I go about that kind of situation, sir?
Oh, fantastic question. Yeah, at least. So your question has to do with jurisdictional challenges, and really, the what your question is asking is, how do we deal with issues of jurisdiction in a global world? So how do we protect IP in a global, when you're offering a product on a global landscape? I would say the first, IP is, as you said, territorial. So what that means is, if you want to protect your IP, or if you have customers in a particular jurisdiction, then you should seek to protect it, in that jurisdiction. The other thing I would reference is that cyberspace is not at large. Cyberspace isn't this, it's not this space that is at large. So there are always, every platform has its rules of engagement. For example, Google Store is a platform. The App Store is a platform. It has its rules of engagement. And we would note that in the App Store, there are some apps that are restricted to certain geographical regions. For example, some are available, some apps are only available in certain app stores, and so on and so forth. Excuse me. So the first question you have to ask, and this is a business decision, would be, where are the jurisdictions that we have an interest in protecting our intellectual property? So if for example, we are offering our service primarily to Nigeria, then of course, as a no-brainer, your point of registration should start from Nigeria. If we're looking at providing a service to Canadians or Nigerian Canadians, some kind of what do you call it now? Cash swap or forex transaction platform between Nigerians in Canada and Nigerians in Nigeria, then of course you know that you should get some sort of registration primarily in one of these two jurisdictions, preferably in both, so that you can market your app effectively, and if there are issues, those issues can be resolved in either jurisdiction. Of course, we've talked about, when talking about trademarks, for example, you cannot enforce a trademark, or it will be difficult to enforce a trademark in a jurisdiction where one does not have registration. Although trademark laws allow for certain exceptions, the well-known mark exception, for example, and similar exceptions, but it might be very difficult to argue from the point of view of an exception. It will be more difficult. So I would say that number one, all platforms have their rules of engagement, and these rules of engagement are becoming more dynamic. They're very dynamic, but then they are becoming more. They are, as time goes by and as developments in fintech and regulation grow, these regulations are being fine tuned. I'll give an example. In the early 2010s, when Apple and Samsung went around the world fighting trademark patent wars, that was the Apple iPad versus the Samsung tablet, the Galaxy Tab. They didn't come to Africa. None of those patent battles happened in Africa. But in the 2020s, of course, Africa is a major player or a major factor in the conversation. I think the iOS store or the Apple store, the Nigerian Apple store was opened maybe in 2014 or 2015, thereabouts. I remember I bought an iPad. I was fortunate to get an iPad shortly after it came out, and I had to use a family member's US address to register, my iOS account, my App Store account. So they had a situation where Africa was not even on their bucket list or on their list. But once a market emerges, then of course the need to seek protection in that market becomes paramount. At the same time, too, one of the big challenges that cyberspace presents is also that companies can operate from afar at an arm's length without any form of registration. You can ask any Bolt driver will tell you this for free, that Bolt does not have a physical presence in Nigeria. And the absence of that physical presence has its implications, because on business and on the users of the application. But the answer to your question is that the protection should be sought in every jurisdiction where that product is to be used. I hope, and so the fact that intellectual property rights are territorial in nature is it's not a bad thing in itself. It only means that you would have to ensure that you protect your IP in whatever jurisdiction you are going to be transacting business in, primarily. I hope that makes some sense. Hello, Dennis. Can you hear me? I'm not sure I can hear you.
More questions in these directions, or are we ready to call it a day?
Okay, I still have one more question, sir.
I'd love to hear from you. That's Hope, isn't it?
Yes, sir. I still have one more question.
Okay, Hope, please shoot.
So the question is, what are the key intellectual property challenges that fintech companies face when developing their innovative financial technologies?
Can you think, what are the key intellectual property challenges?
Yes, that fintech companies face when developing their innovative financial technologies.
What are the key intellectual property challenges
sir.
That's a very intriguing question. Okay. What are the key IP challenges? I guess that would be, it's a interesting question. I think that's primarily a Nigeria question. It's a jurisdictional question. I would say that from practice, from a practice point of view, I would say the first challenge would be ignorance. And that ignorance would probably have to be centered around user ignorance. So ignorance on the part of or lack of awareness. Let's say lack of awareness. That sounds nicer. On the part of the FinTech owners themselves. So many FinTech proprietors are not even aware of the need to protect their intellectual property or the fact that they even have intellectual property in the first place. And that is not to say that intellectual property, the fact that one recognizes one's intellectual property, that that will automatically mean that the what do you call it, the persons that FinTech offering or that FinTech platform will blow, quote and unquote. It doesn't necessarily mean that the platform will be popular or will be accepted by the public. But I think this issue of how knowing the nature of what they have, I think that's very key. It's a very key, it's one major challenge. I think I'd also mentioned that dispute resolution too is another major challenge. Most times, by the time the parties are trying to sort out the disputes, or when parties, the time that it takes, I have some of my FinTech clients, especially developers, they don't have time for the challenges of our justice system. Most times, if you work with any developer, they want their solutions now. Now. The same way when you hit send on your FinTech, whatever FinTech app, you don't expect the app to start telling you stories. Nobody wants to hear stories. You just want to hear that the person has received, the recipient, the sender has sent and the receiver has received. So I think there's a dispute resolution deficit. One of the ways that a company like AliExpress deals with this is AliExpress uses a proxy system. They use what do you call that thing now? Not proxy. Proxy is not the right word. Escrow. They use an escrow system to resolve customer disputes, and most times they weigh in on the side of the customer. So they use an escrow system, and that tends to work. So I would say these are two major challenges. Of course, I think the most important challenge is regulatory somersaults. So we're talking about how the regulator responds these days. And one of the things that's happened in the very recent past is the Consumer Protection Commission, the Federal Consumer Protection, Competition and Consumer Protection Commission, stepped into the process of regulating or got involved in regulating deposit money banks. So FinTech companies that provide not deposit money banks, that provide digital money lenders, yes, that provide the lending service offering. FCCPC got involved and started issuing some sort of license. The process is very onerous, it's very tedious, and I don't think it helps to manage this sector efficiently. That's my opinion. But you find this is, again, just shows that regulation will always rise to meet the current realities. So I think that's a major challenge. Of course, in the past, we've seen CBN wake up and change regulations overnight. That has also been a very big challenge. I think these are some of the, so we have institutional challenges, there are regulatory challenges as well, such as with CBN, and then the economy itself is not stable, it's not very stable right now. So that climate also is a challenge to many fintech, to the operation of fintech companies.
Okay,
so,
thank you.
Yes, thank you.
Thank you, Mr. Fularins, for helping us with that question. All right, I think we'll soon bring a curtain to the close of class, a curtain on class. And before we just do that, we would just like to have Mr. Fularins, if you don't mind, maybe any closing words you would like us to know, anything you would like us to know as regards maybe as lawyers and fintech as enthusiasts entering into the fintech space. Is there any other extra knowledge you may want us to know as regard entering into this space, in terms of maybe when we become practicing lawyers, advising clients who are going to advising fintech clients on their intellectual property protection?
Oh, fantastic. I think there's quite a lot. The conversation is a very open one, especially here in Nigeria. So I would say that there definitely is a lot to be said. Number one, I would say things to note in conclusion. I would say that one has to think outside the box, really, if you ask me, because this is it's new in the sense that, I mean, there are many services that, like we discussed at the beginning of this conversation, that there are services being introduced today that did not exist 10 years ago or even 5 years ago. There are some services that, of course, one could say were quite obvious, like credit swap transactions. Maybe 5 years ago were obvious. 10 years ago, they may not have been so obvious. The fact that you could convert credit to cash, even though the concept would not have been so wild, but 20 years ago, it would have been actually a very wild concept. So I don't think we have seen an end to the type of services or the types of services that can be provided as financial services. I don't think we've seen an end to that yet. So I would say, the first thing I would say is, you're on the right path. Please don't stop learning and don't stop talking, because I can assure you that these issues are far from, they're not settled at all. We're still figuring a lot of this stuff out. So please, engage on platforms like this, in programs like this. And I was saying, when we were asking when Dennis was asking for questions, I was saying that you could even Google questions, because I think it's very important it's important for us to have this conversation. And I won't even mind if you Google questions to see what type of questions should we ask, because nobody knows everything. I actually pick one or two things from some of the questions that have been asked here today. And I can assure you that those questions will, maybe the next time or sometimes, sometime if I have a conversation with a client, these questions might feature, or some of the issues raised by these questions might feature very prominent. So I would say engage more on platforms like this. And I'll be very happy to engage with you guys. I can be reached. I'm on social media, but I think emails, I'll probably put my email in the chat. Emails are probably the best way to catch me, but you can catch me on social media very easily. I'm on Twitter, Instagram, Facebook. I'm a ghost on some of these platforms. I'm on LinkedIn as well, so you can connect there. Of course, I do a lot of work with the Intellectual Property Institute, so that's also an easy. You'll find me easily if you check me out there. But engage. This is a fantastic platform, and I must commend the JIIPCC team and the coordinators too. Dennis, well done, and it's Amina.
Yes, sir.
Yes, Amina. You guys are doing a fantastic job. These skills, I can assure you, will come in handy, in the future. And but as FinTech practitioners, I think you should take one of the things I do is, and my phones tend to suffer because of that, is I use apps a lot. I use a lot of apps, and I would encourage you. I'm not saying don't start taking loans on loan apps. So I'm not encouraging anybody to take loans or download betting apps. But I download many of these apps because I have clients who provide the same service. So you always want to know what the competition is doing. So I have OPay, I have PalmPay, I have this pay, I have that pay, I have whatever pay, because we're always looking at, okay, the onboarding system, how quickly do they onboard, how easy is it to onboard, what are the KYC requirements at the first instance, what are the limitations on transactions, things like that. Operational stuff. It increases your value as a consultant, as a lawyer. When you don't just know what the law says, you also know what the operational situation is. So I hope that information helps.
Thank you for sharing this particular topic.
Thank you.
All right, for our mentees, can we just have you that we can take a send it to it on your okay. All right, thank you very much. We're done with that. Thank you once again, Mr. Folarin, for joining us. Our mentees, reach out to me on Mr. Folarin's email so that we can share it with you. If you have questions that you want to send to him, if you want to engage him, you can do that. And I'm sure Mr. Folarin would love to have you reach out to him. So thank you once again, sir. Thank you for sparing out your time to be here. Able to stay true to the call, to the end of the call. Thank you so much. We'll see you guys in the next class. Take care, sir. Take care, everyone.
Thank you very much, everyone. Thank you, Dennis. Thank you, Hope. Take care.
Thank you, sir. Bye, sir.